As we initiate chaos theory guarantees that we'll play like lightning shots sounding like thunder. For every time in the face that it hits us, we're faster. Well, they should know by now. They see the world keeps trying to shake us. It only waits us. The pendulum swings. The pendulum swings. It's in a beautiful darkness. Only another. It's full steam ahead. Full steam ahead. All about the Petty Express. Misdirected from the start. It's a runaway train. I come a freight train. I come a freight train. In a beautiful darkness, the Petty Express. In a beautiful darkness.
Hey, you guys, they started a bit early, so I decided to start a bit early. Let me get a little sign over the court TV. Uh, just as a quick kind of reminder, this is going to be outside of the jury's presence this entire day. This is going to be to try to figure out if there was a Brady violation, what to do about it, if it's going to mistrial, that kind of thing. So, thank you for joining. Let's get going. Oh, they must have just started the feed sooner, but that's okay. I have been impressed with this judge, although he does make me want to go watch Home Alone. But I figured we would. He seems to be on time, unlike the courtrooms in California. Thor, the couch pirate, is with us. I will say he does seem to be a very thoughtful, very calm judge, which I think you do need in a highly volatile and heartbreaking case like this. I know he just looks, I mean, if he hasn't been that man for Halloween, sir, you're missing a trick. That should be your permanent Halloween and Christmas outfit. Now, I did ask ChatGPT because, how likely it was that this could cause a mistrial. And they were saying that if a lesser method was able to remedy, then, you know, a mistrial would generally be avoided. However, the placement of the evil monster on the south side of the building about the time that Adrian Garcia would have been, in that vicinity is incredibly prejudicial if the state was unaware or didn't tell anyone. Mr. Mo was like, "Oh, so are you done for the day?" I was like, "With one stream. I'm getting ready to go into another stream." I love Mr. Mo, but I swear I tell him my general schedule during the day and then he forgets it during the day. And we're only a couple minutes early, but it looked like they were starting to film, and I didn't know if maybe we might get some inside information. It does look like a lot of the parents are in the courtroom today, which I would be if I were a parent. And I do worry about the potentialities if there is no remedy but a mistrial. I I can't imagine what these parents are going through, and to have, this kind of turmoil already in the trial, I can imagine it's making this all that much harder. Howdy, howdy. I will say that I have not been a fan of the way the state has presented the case. It seems like they are leaning heavily uh, into pulling on the heartstrings, and I know I only have yesterday to go by, but it seems like they are running this case against the school unaliver and not this particular cop. We're hearing a lot about what happened, but it doesn't seem to be leading to where this officer in particular was negligent. And it brings up other tougher questions. Why is this officer charged with 29 counts of negligence when the chief of police is only count or charged with 10 as of right now, and his trial date hasn't been set? I mean, if anyone can take sort of overall, negligent claims beyond the school, beyond the multitude of things that failed, that chief was the nexus of all the cock ups in this. In what happened, he was the one who decided that the assailant was no longer an active shooter, but a barricaded person. He was the one that decided they were going to look for keys. He was the one that decided they were going to wait and try to, call the unaliver on the phone. So why Chief Arredondo hasn't been, why we aren't doing his trial, I don't get. But it will be interesting to see what happens today. And as always, I will be doing a breakdown at the end of this stream, so I completely understand that this is an incredibly difficult trial. So if you just can, if you, can't do the live stream, but you can do the breakdown, that is completely, I mean, that explains a lot. I just, I don't see where this officer uniquely dropped the ball in relation to the hundreds of other officers that were there that could also be argued dropped the ball. So it does seem odd that this is the officer that was charged of all of them that were there, and that the chief hasn't wasn't charged first. Something is rotten in Uvalde. And if we go by what yesterday was, I believe that the state is going to bring in every emotionally charged witness. Oh, what happened in Minneapolis? My I kind of let my brain take a siesta. ICE agent in Minneapolis open. Oh my. Yeah. Wow. Well, I was unaware of that. Howdy. I'm glad that all the families are there supporting each other. Like I said, these parents have my deepest respect. I can't imagine what they've gone through, what they've all gone through. And it bothers me if the state made a stupid mistake, didn't take enough care with this trial where they want to act like they're the only one that care about the children. And if they made such a stupid cock up that they're going to cost, whatever sort of justice this trial is, because I don't know, I'm trying not to be too quick to judge, but this just seems all kind of wrong to me. So I am hoping that maybe somehow, some way, welcome, welcome, photo lady. And for those of you who maybe didn't hear or are interested, at the Nick Reiner, well, it was supposed to be an arraignment hearing. Alan Jackson withdrew from defending Nick Reiner. He has been given a public defender, and the arraignment has been pushed back to February the 23rd, I believe. I will have to double check. I wrote it down in my notebook, but I'm in a separate notebook for Uvalde. I don't know if anyone has a brain like that, but once I've closed one notebook and opened a new notebook, I don't sounds terrible. I kind of hyper focus on the next thing. I will say, I have like the defense. I am confused about the suspenders, but that's just because why would anyone want to wear suspenders? That seems more uncomfortable than a belt. Anytime you could put on audio.
I'm handing you Defendant's Exhibit A. I did not file it because I just, with the filing system, and it is our defense strategy, it's what you asked for. I would just ask, I know
It'll
you'll
be
have to
sealed.
file it, but ask that it be sealed after you.
Yeah, it'll be sealed.
Thank you.
And you had your notes, Ms. Mitchell?
The record reflects that I'm tendering to the court my notes, all of my notes. To the court, my notes on witness Aaron Robin and Maria Chavez, who are also teachers that would be located on the south end of the building.
Okay, these also were tendered to me in camera, so they'll be sealed as well after I review them.
I just wanted to also clarify for the record, Your Honor. So yesterday when I testified, after I testified, I, off the record, told opposing counsel, and I want to put this on the record, that I had not reviewed Stephanie Hale's interview with the Rangers at the time that she appeared for trial preparation. I went back to my notes. We interviewed her on December the 10th. At that time, I had not reviewed her testimony to the Rangers. It wasn't until...
What the hell is your job, ma'am? Look, I understand this is a incredibly big case, but why didn't you review the specific files for that specific witness when they came in? I mean, you were over here telling the defense that you gave them everything. You didn't even look and, fulsomely prepare yourself for your witness. And yet your partner in action wants to act like you're the only people that care about kids. It's a little irritating that you could give less than a half-assed, job about it.
The week of Christmas, I think all around December 26th is when I started pulling the witness interviews with the Rangers that I reviewed for actual testimony to the Rangers. So the position that I should have had an epiphany on December the 10th when we interviewed her in anticipation of the trial is misplaced, and I just wanted to make sure that was on the record to clarify.
Yes, Your Honor, and our position on that would have been the epiphany should have occurred on the 26th when she reviewed it.
Yeah.
Okay, well, I'm going to review these documents that have been tendered to me in camera, but I will, obviously at this point, take any motions or arguments as far as remedies or proceedings in this matter. So, defense?
Yes, Your Honor. So, as the court will see from what's been tendered as far as our defensive strategy, this situation did have a significant effect on the strategy from voir dire all the way through, and through future witnesses, should they be called. We're in a position where we know under the law that we have to ask the court for a mistrial to preserve the record. However, if the court was not inclined to grant a mistrial, we do have other remedies we'd like to discuss.
Well, let me just say this. Under Heath, the greatly awaited case from the Court of Criminal Appeals about the court's discretion and power to basically, if there is a Brady violation or a Morton violation, to have the ability to exclude that testimony. And they clarified that the prosecutors, it does not have to be an intentional act. And I'll say for the record that I find, based upon what we heard yesterday, that this was not an intentional act. At best, it was a negligent act, or at worst. So I do have the remedies under Heath available, but, you know, if you're making your motion for mistrial, I will tell you, I don't believe what I've heard so far without reading although I have summarized what you gave me, and I kind of already had an idea of what it was. So I guess my question is, since we talked about yesterday, the three things that were complained about was the puffing, her seeing the dirt being puffed up. Number two, identifying or saying that she saw the individual for the first time, and the location. All right, my question is on the location issue that she testified to yesterday, and frankly, I think that was kind of a very quick testimony. I'm not sure that it resonated with the jury, but my question is there going to be other witnesses that put that individual in the same location that are going to be called later by the state?
Your Honor, I would say the most probably compelling testimony are the casings in the case that would either corroborate or override what she said. I believe the location that she placed, she's from probably in the neighborhood of 100 yards away, looking toward the south end of the building, and she puts, I believe she marked in a general area south of the building, the casings are going to be closer toward the west side of the building. That is, they're going to be further west by as much as 10 yards. I haven't figured the exact date. So a witness from 100 yards away placing a witness within a 10-yard distance, that would be the distinction. The other potential witness, Melanie Flores, testified that, would testify that the gunman, as she saw the children go into the south door, she saw the gunman at the south and west corner of the building, which I believe her testimony will put it halfway between where the casings were and where this witness says it was.
Okay. Well, I did a little research last evening, and again, I don't want to. I've reviewed your in-camera explanation of how this affects your defense strategy, and I'd already kind of gleaned what it was. So I can tell you, I'm going to deny the motion for mistrial. You have made it, and you've preserved your record. Again.
Yes, sir. In addition, can I just, so I can make sure it's clear, because we all know how the courts start interpreting it later. We will go with whatever remedy the court decides that we can decide it. However, we do not believe that it's a sufficient remedy, and mistrial would be the only.
Yeah, I'm going to deny the motion for mistrial over your objection, obviously. And I'm going to find under Heath, although it's not a prerequisite, that it was not intentional by the district attorney's office. It was negligent, and I don't believe what was testified to in front of the jury resonated enough to significantly affect your trial strategy. But what I am going to do under Heath is I'm going to exclude her testimony.
We have just before you do that, really, I just want to know we have a response if you would consider that. So.
We would also have a response to that, and just so we can explain to the court that our primary concern with an exclusion is that basically what's happened, and I understand the jury, and you'll instruct the jury to disregard. I think a lot of that testimony, though, is going to be difficult for them to disregard. A lot of it is emotional testimony.
Yeah, that is.
One of
it
the
was
things
very
that
emotional.
we were thinking about as a remedy would be to allow us to play her statement to the Rangers in its entirety to the jury, so that they can hear what she said in the first 4 days.
Well, I was going to give the option of, even if I exclude her testimony, you still, if you wish, could cross-examine her and do that.
Okay.
And then at the conclusion of that, my thought could be to exclude it at that time.
Yes, Your Honor. It's like, because I guess my concern would be if we excluded it now and they haven't had an
Well,
opportunity for.
I was going to give you that choice, but you
Yeah.
jumped ahead of me.
Sorry, Judge, I'm sorry. I got a little afraid, I'm sorry.
All right, Ms. Mitchell, what do you have?
Your Honor, we just have a state's response to the defendant's motion to exclude the testimony of witnesses SH in anticipation of their motions. I just want to file that with the court for the court's consideration. If you could file stamp this copy too.
Okay, well,
And that's my copy.
Good.
The first copy's for the judge. I'm sorry.
okay, thank you.
I just want to file stamp copy.
Okay, so
Yeah.
again, this is kind of a sua sponte remedy that I've devised. It's not really their motion.
So the judge is just tinkering with his own remedy. He does have the power to do this. I'm just wondering if this is going to be more fodder for a possible appeal.
Did you file a written?
Nick,
Did you file something?
No, no. Your Honor.
Okay, okay.
this is just anticipation of an oral motion to
Okay.
exclude, Your Honor.
Okay.
So, I don't know, Your Honor, can we confer as to possible remedies and see if we can come up with a solution? Would the court be open to that?
I mean,
Or no?
if y'all agree on a remedy, I'm happy to entertain that, but I want the record to reflect that pursuant to Heath, I do have, discretion to craft a remedy any way I see fit. But what I've already done, for the record, is we have given a continuance to the defense until tomorrow, and we're having a hearing outside the presence of the jury to entertain potential remedies and make findings of fact if necessary. But for the record, there was a motion for mistrial, and on that motion for mistrial, I'm going to find it's denied because I think the remedies available are sufficient to protect the due process rights of the defendant. And if y'all want to agree on a remedy, I'm happy to entertain that, but I have one in mind, and I'm going to give the defense some leeway on how they want to proceed with the witness in front of the jury in the event she's recalled after we talk. So take 15 minutes, y'all talk, and we'll come back into court, and I'll review the state's response to the oral motion and finish the other in-camera matters.
So, that's okay. Hey, Baker Raiders, you are actually coming in at a good time. I can kind of give you a breakdown on what went on. So, day 2, if you guys were not aware, this is actually a, Brady hearing because the state might have had a Brady violation yesterday. Yeah, the first day of trial. The witness, the final witness yesterday was one of the teachers in the elementary school during the time of the active shooter. Thank you so much, Jay Walsh. I appreciate it greatly. Where did I put my... So the digital notebook has a stylus, and you would be amazed on how many times I've almost messed that up. Welcome to the Church of Mo. We have dark chocolate sarcasm and, dark humor and true crime addictions. Look, we are perfectly imperfect. So, what has happened? Basically, yesterday, and hi, expert. Hi. Did you want to come on, or did you just have too much sugar? Sometimes I can't tell. But basically what happened is this continuance was offered by the judge because yesterday evening, toward the end of testimony, this teacher, apropos of basically nothing, and in direct, contradiction to the statement she gave to the state troopers, very like 4 days after the incident, uh, basically her story changed, and her placement of where the monster evil person was uh, basically puts that person in closer proximity to Adrian Garcia, and he might have been able to act. Now, the defense in this case has been very clear that their defense is going to be the actual timeline. Who knew what when, what information was going on, and the placement of where this human monster was when Adrian Garcia arrived on the scene is very important. The defense was blindsided yesterday when the teacher basically placed the unaliver on the south side of the building in eyesight of where Adrian Gonzalez would be. Now, her grand jury testimony was also different from her testimony that she gave to the Texas Ranger. In the grand jury testimony, she talked about seeing puffs of smoke while she was out on the playground, indicating possibly where bullets were landing. Now, evidence and shell casing show that there were never any bullets actually being shot over there, but due to acoustics, it was very hard to figure out where the shots were actually coming from. That being said, those were new things that came out in the grand jury during, and that she had seen the unaliver. Well, today, for the first time in testimony, she actually said where she saw the unaliver, she placed him on the south side. And that was something that the defense was not told about, that her story had changed at all. Now, they believe they were given a copy of her grand jury testimony with all the discovery that would have indicated that her story had changed from not really seeing anything. And her story is harrowing. I don't agree with the judge that the jury was not engaged to her testimony. It was heartbreaking and heart-wrenching to hear her talk about, she and her fellow teachers arming themselves with scissors, and how the little kids in her class all armed themselves with their safety scissors because they saw their teacher. So I don't agree with the judge that this was not impactful, that it wasn't engaging. It was harrowing testimony. It was not easy to listen to. You could tell that she was still greatly affected by this. It's hard to unhear those things, and I don't know that a juror will be able to change that. But basically, to boil it down to very simplistic terms, the three things that the defense is upset about, the kind of things that have changed in her testimony throughout the duration of her being a witness, are her talking about the puffs of smoke, which she didn't talk about during her Texas Ranger interview 4 days after, that she had actually seen the shooter. And she was asked during that Texas Ranger interview if she had actually seen him. At that point, she had said no. Now, I do believe that the defense is doing a very good job at gently questioning the people that have been involved. I do believe we are in for a lot more very hard to listen to, harrowing testimony. The state seems to be very, very vehement about using the most gut-wrenching evidence. So I am worried. It does seem, and again, I'm not a lawyer. We've only had 6 hours of this case, but the state seems to be putting on a case against the school unaliver and not this cop in general. We find out that yesterday. So for today, the judge has denied a motion for mistrial. Now, the defense did, put their motion for mistrial up for the record. The judge felt that under Heath, while this lapse of talking to the defense, or communicating to the defense that her testimony had changed. While it was negligent, while it wasn't, good, he ruled it unintentional. So it seems like the judge has spent this evening kind of figuring out his own remedy. But the state asked if the defense and state could work together to try to cobble up some kind of remedy. Now, this does raise questions if in the first day we already have the state admitting that they didn't look through her prior testimony when they were getting ready to, or going through her testimony. I doubt that this is going to be the first time. The state seems very, very unprepared, which is a bit shocking. Expert, we're going to have to get together and watch the opening statement if you want. I have never seen a prosecutor cry during an opening statement. And you guys, that's why I couldn't be a lawyer. Look, I know I would cry if I had to try to talk about this. I'm not without a soul. I do have one in a jar in my closet. I take it out on like leap day. Give it some fresh air, put it back in the jar. But I've never seen a prosecutor crying during an opening statement. Let me see. I'll send you an invite if you got time. But it was really weird. And no obligation. This is an incredibly difficult case. So if this is one you'd rather bypass, absolutely no worries. I haven't even, I've been waiting for Nick Reiner and Alan Jackson. Thorbert, no, you're fine, Thor. You're just being a booger. Yeah, it's I will say the state is acting as though they are the only ones with the sort of corner of moral good. This seems more like a political stump, and maybe that's just how I'm looking at it, but I really don't like the way the state is running its case. I feel like this is going to be the direct opposite of the Darrell Brooks case. In that case, the state was very fastidious to not, try to put the jury through all of the, gruesome pictures that they could. They didn't parade all of the child victims forward. I don't think we're going to have that kind of prosecution here. This prosecutor seems to want his pound of flesh. And unfortunately for the people of Uvalde, for the rest of us left behind, the monster has been slain. We're left with dumbasses and jackasses. And yes, those who allowed this situation to become the cluster F that it was need to be held accountable. This should not have happened. It should not have taken 77 minutes. But I don't get why this particular officer, out of the 387 that were there, is the only one charged. Why isn't the chief of the school district resource officers, who was the de facto, command operator or command of operations, why is he only charged with 10 counts and this officer is charged with 29 counts? This is very strange. And I worry that the state is already doing a lackluster job, and it's going to lead to more heartache to the families, friends, relatives, community left behind that just desperately want to see something, some accountability, something, happen. We also learned that the Texas Rangers yesterday searched the school shooter's truck. Instead of securing said truck, they decided to leave it out overnight. It rained, and because it was driven into a culvert, it got flooded. You guys, they make Canton look functional. So it is going to be interesting. I do like that judge did sit down and think. about a remedy, but I honestly, I disagree fundamentally that the jury was not swayed, that the jury was not, that the jury was not engaged with this testimony. It was the end of the day. I was tired, but I was engaged with that testimony. I could not look away. I was trying to write notes, but I was listening. I was cooked. So I fundamentally disagree that the jury was not engaged. Now, on that note, um, depending on the time space continuum, I am planning on breaking down and reading through the entire DOJ critical after report. So the DOJ after report on this is available online. Now, it is 610 pages. There are going to be a lot of videos. I'll probably chunk it out to about hour streams. I might do this really early in the morning. So if you don't see my bright, shiny face, that's because I'm talking to you before I put my face on over my catillion, put my people suit on. But I want to get to I don't feel like this trial is going to give us a lot of answers. So if you want some of those answers, that's kind of what I'm doing. I also know that I find it nice to have kind of longer form videos that I can just listen to in the background. So I am going to start reading some of these longer documents and putting them in long form video. It's kind of like my own bedtime stories, although the subject matter is quite grim. Howdy, howdy. Hello, hello, hello.
Hey Mo, what's going on?
Nothing, just trying to figure out what in the space-time continuum happened, because we have a Brady violation on the first day.
I don't even know what's going on.
It's
What are you watching? I saw Uvalde
Uvalde
earlier
trial.
listed. Oh,
Yeah, and then I waited for years and years for California to get something done for the Nick Reiner arraignment, which has now been postponed till Feb. Expert, why is
yeah.
it? No, look, this is the second time this week I have tried to be prepared, like I had a stream like planned, and then the whole trial goes.
Oh, yeah, that's how they always do. Yeah. Yeah, trials suck. They absolutely suck. I mean, it's the worst thing in the world. That's what, I don't do
No,
that stuff.
this is going to be the worst one. The state is bound and determined to swing every single deceased child and use them for political points. This is not a good. This is them essentially putting a trial on against the school shooter and not this cop.
So I don't think I knew you when the Uvalde thing happened, did I?
I think I was very soon. I was really new to streaming, I think.
Okay, so I mean, I didn't know you till a couple weeks ago. So I covered it when it happened, and it was such a cluster. It was just the whole thing was so stupid. You go back. I mean, the whole conspiracy about Discord and all that, right? Like the guy was like said everything he was going to do was on Discord and everything, and then you had before anybody knew it, the state came in. The state, I don't even know which agency in Texas, but anyway, the state came in, did their investigation, said the police screwed up. I thought it was kind of done. I didn't even know there was a trial still going on. So what is this? What do they have on trial right now?
This is the acting resource officer. So he wasn't the resource officer for the high school. Give me 1 second.
You're welcome to verify. The clerk is sealing those documents as we speak.
Thank you.
The
Okay, she's ready to go. So once again, we're outside the presence of the jury, and I'm giving counsel an opportunity to confer on potential remedies in regard to the witness. So what do y'all have to report?
Judge, we've had pretty productive talks, and I believe, and correct me if I'm wrong on any of this, that the proposition at this point, with them still reserving the right to think of it overnight and start in the morning, is that they continue their cross-examination. They get to also play the entire statement that she made. We would then get to redirect, and then they still reserve the right to ask you to exclude all the testimony. And
Yeah.
that part we feel comfortable.
Yes, Judge, and under the idea that we want to unring the bell first before there's an instruction to exclude it, because and have them exclude it all in its entirety, which is fine. But we would like to be able to unring that bell and then make that decision. Depending on how that cross-examination goes, we might not ask to exclude her, because there are some things that she says that we're just trying to evaluate her testimony after it is to see, on balance, is it more beneficial to our case or is it not? Like, after we've unrang the bell. But if we determine on balance that it's...
Jay Walsh, basically the state is saying that this officer in particular is uniquely responsible because he was the first officer affiliated with the school district. I don't know if that's why they picked him, but he was the first officer on the scene. There were no officers or resource officers assigned to the elementary school. He was assigned to the high school, got a call about a possible car crash near the elementary school, went over to see what was going on. Now, simultaneously to this, across the street from the school, people were coming out of a funeral home to see if that person who had fallen or driven into the culvert was okay. They're on 911 saying, hey, there's someone in an accident. Adrian Gonzalez is hearing, okay, someone's in an accident. About as they get halfway across the street, they're starting to get shot at. So the man quickly says, hey, we're getting shot at, we're getting shot at. He also sees the school shooter throw a duffel bag over the fence and hop the fence, starting walking towards the school. Now, dispatch, we don't know when dispatch relayed the information that someone who was shooting was walking toward the school. According to the defense, Adrian did not hear about the shooting, but saw someone laying down or had tripped to try to get away from the shooter in the back playground area. So he went directly to the downed person. At this point, according to the defense, the shooter is in between two cars. So you might not have seen him if you're running past with your eyes focused on the downed person. Now, as the shooter starts walking up the building to where he's going to eventually enter, he is confronted, or 3 officers were able to come from that direction, saw him entering the school, asked if they could take a shot, but didn't for some reason. And then we had the 70 minutes of waiting. So that's kind of what we've got thus far from the trial.
And the prosecution didn't give all the information to the defense?
So what it seems like, the prosecution had this witness come in. They hadn't reviewed her prior testimony, or at least the testimony she had given to the Texas Rangers. Now, I am not sure if the defense also got her grand jury testimony, but from what the defense had at least knowledge of, they had the knowledge of what she said to the Texas Rangers. All of the puffing smoke, the IDing the shooter, and location of the shooter were things that this woman never spoke about in the discovery that they had access to, according to the defense. So this woman gets on the stand yesterday and basically says, oh, I saw puffs of smoke. He was over by the south side. He was, here. Oh, the defense did because he reviewed it during the argument yesterday. Thanks, Jedi Jess. My brain was
So the defense
somewhat
did get
mush.
it.
Oh, yeah. There's a lot of hinky stuff going on here.
Because yeah, I thought you said it was a Brady violation was being brought up.
Well, it was the potentiality,
Yeah. Okay. I got you.
but the judge determined that it was neglectful, not intentional. So
Well, neglect is still. It's not
yeah,
good.
you shouldn't. Yeah,
Um.
you shouldn't do that.
No, you shouldn't. Well, the prosecutor here is sitting here saying I'm new at this too. I like that. That's always. This is BS, man.
What the hell is this trial? Expert, yesterday I must have said, "What the hell is this trial?" at least 87 times. I was like, "Am I on Quaaludes? Did someone spike my?"
Well, here's something I'll tell you. You're from a normal state. This is Texas. Okay, Texas is they're their own country, you know. So like their laws a little bit different too. It's kind of like a Commonwealth. It's a little different. Texas is a little odd. But of course, you know, they're next to Louisiana and they have some rivalry there, which is a weird thing. And Louisiana, you know, we just all write it off. It's Napoleonic. So all their like little procedures and everything else, it's all weird. And that's what the thing really bugged me when I first started doing YouTube stuff. So like watching people, you know, a lot of tubers sit here and they critique all this stuff like, oh, you should be objecting and all this stuff. And I'm sitting here going, what are the rules in the state that this court is in? Because it may not be a rule. That may not be something that's objectionable or whatnot. O-line Red knows what's going on.
Yeah, so the piece the defense didn't get was the location near the south door and the pretrial interview where she described the shooter go to the first time and they never asked where she saw them or where he saw them. So basically she, in their pretrial interview says, oh, I saw the shooter. Now, no one sitting in the prosecutor's office in this very big case asked, where'd you see him? That's what they want us to believe, that in a case like this where the location of where, you know, this person was at what time, a witness who hitherto now has not said they've ever seen the shooter, then comes out and says they've seen the shooter, and the state is saying, we didn't ask her any follow-up. So the judge is looking over her, the state prosecutor's notes to see if any questions were asked.
This is day one.
This is day 2.
It's not gonna get any better, Mo.
I know. It's gonna be 4 weeks of this.
Let me tell you my secret on cases. Opening arguments, closing arguments, and sometimes there's maybe an interesting witness or two. Maybe. But all the procedures of all this stuff is stupid. Oh my gosh, it's so dumb. That's why I don't like courtrooms.
You picked the perfect profession.
I wrote letters. I was a letter writer.
Hey, that would be my thing. And Alan Jackson quit Nick Reiner. I'm guessing
Really?
Yeah.
Why?
So everyone is reading between the lines that Nick Reiner doesn't have any money to pay for his retainer or his continued support.
Well, that's probably, now we know why there was now we have motive.
Yeah, that's the thing. So the arraignment has been postponed until February. All right, let's see why the judge looked like I feel like the judge is going to say, it's not a tumor.
He needs a Tylenol.
Okay, expert, who does the judge look like?
Less beneficial. We would still like to have the Heath remedy for the late disclosure.
Well, for the record, I'm offering it right now.
He's in your favorite Christmas movie.
Bob Newhart?
No, the old guy from Home Alone. You know, the one
I
we
do
thought
love
was
that.
the scary
So I was
killer.
going to say that, but you okay. I thought that at first, but I was like, no, that's very abstract. It's very out there to say that.
No,
And
no,
when you said
JKD Buck
favorite,
saw-
I was thinking, you know, Elf and Christmas Vacation. Yes, he does. He looks just like the guy that shoveled.
Yeah.
I'm offering the Heath remedy to exclude her testimony immediately. But if y'all want an opportunity to try this, if both sides agree, I'm happy to, implement that agreement.
Yes, Your Honor, what we believe is ultimately, we believe we're asking the court to exclude. The only issue is that we just want to be able to unring the bell first,
All right.
is the idea.
And I know I told her, but she knows she's supposed to be here at 9 o'clock tomorrow. Okay.
Yes, Your Honor. Additionally, I will say that, that in light of it, whatever harm that the court has determined in the defense case strategy or in emotional impact, we would add that, and we do believe that under our 403 motion and motion of limine under the autopsy photos and the like, that it would start to, that the court should add that in the 403 balance. Because part of what was not disclosed is something that is, I guess, on an emotional level, especially in what this witness testified to has a tendency to prejudice the defendant. She was taking shots. She was actually personally traumatized by these things that we are going to show that she has never said before. But the jury, having heard that, we believe that it should be a part of the 403 balance when the court eventually, I know you haven't made your final decision about what it is, but I would just, for the record, I would say that it can compound the harm if there's a disclosure, and then the probative value, whatever that is, of them trying to get into these photos of these children are, the prejudicial danger is compounded by something like this occurring in the trial, as to how it can affect the jury. And so I just wanted to put on the record now, I know the court hadn't made the decision, but just to put that in the court's mind that we are also going to be arguing that at a later date.
All right.
And Judge,
That
I
guy's
just
a
wanted
good
to be
argument. He
clear,
had a
because I
difficult
originally
time
heard the
trying to
court
say it, but Rule 403 in Texas, he's right. He's trying to show that all this stuff can be prejudicial against his defendant.
Well, it is. They had been arguing this. The state wanted to put in autopsy and crime scene photos in the opening statement, and the defense said, no, these are not. Basically, they made the argument that my client isn't the one that killed them. My client, didn't shoot
Victim.
them. Yeah. So
I mean, oh,
So the state stood up on a soapbox like, I guess in Texas it's okay to show pictures of dead adults, but, if we show pictures of a dead kid. It was the weirdest damn thing I've ever seen. Now, the judge did allow the pictures to be shown, but said that they weren't going to be admitted into evidence and that the defense was able to object to them, and he would use his discretion on several of them he found to be too prejudicial, but that some of them were okay.
how does the actions of another quantify, multiply out to the actions of the guy that's at trial?
Well, that's what I don't get, expert. How it's the transitive property.
Yeah.
Again,
I mean, you can do stupid stuff. Like you can have a pit bull and you put it in the backyard and then you don't have a fence. And then the pit bull runs and bites a kid. Okay. You're very much responsible for that. All right. So, but let's say you did everything possible and then a kid jumped over your fence into your backyard. It's I don't know. Maybe that's not a good example. It's just it's that transfer of depravity, because the pictures are depriving pictures, right? And it's how do you transfer with how awful and torturous, and I don't know what type of killings this guy did. How do you transfer that over to something here? It's all showmanship. This is all the entertainment thing for court, trying to convince the jury.
It very much seems like this was the case. The problem with this is that the monster's been slain. The monster is never going to be held in earthly justice. We're left with cowards and dumbasses. And how do we hold the cowards and dumbasses at the top who allowed all of these officers to be poorly trained, to not know their ass from their elbow? How do we stop this from happening again?
Yeah. And
And
sometimes you can't. Sometimes you
yeah.
can't. You know, that's the other thing with this.
Now, her interview with the Texas Ranger was recorded, and that was the one in which she never said anything about taking or being under fire. It was quite harrowing. I'm not taking away from what she experienced, but she made no mention of the gunman or seeing shots fired at all. When 4 days after, when she talked to a Texas Ranger.
Yeah. But she didn't get to be crossed either. You know, I don't know.
No. I will say that the defense is doing the best they can with these witnesses.
Wasn't there something also though, like maybe I've got something confused, or I don't know. I've been on a lot of medications. Oh wait, I gotta go take my medicine today. Today's my last day. I'm gonna go take a shower and take my pills, Mo. I appreciate you asked me to come on here. I was like,
No,
oh,
well,
hey, it's a
that's
break.
what.
I
Well,
need to.
sometimes, I ask ChatGPT, but I don't know the law. But this, and sometimes I'm
Oh,
just like, maybe I'm thinking conspiracy, but none of this smells right to me.
that's why yes. Yes. I get exactly what you're saying. But okay, conspiracy. That's kind of funny because that's what I was going to ask. Was there something involved in like a back door being propped open in this
Yes.
case?
So the defense has already brought out that there was a standard operating procedure at Robb Elementary that teachers were overriding those safety doors with magnets. Now, according to the principal, it was really supposed to only be substitutes because they wouldn't give them keys to the door. But there was also, it came out during the investigation that one of the exterior doors, so these were interior doors that they were defeating with the locks or with the magnets. One of the exterior doors was non-functional locking wise. Now it had been sent to maintenance, but nothing had been done about it. So
Hmm.
there were multiple points of entry within the school that were completely
Did,
open.
did you see the video of the police going in there?
Yeah, I was so angry. I
Okay.
about
I was gonna
lost
say
my
if you haven't, like it's somewhere on my channel. I did a stream
and
on it, and it's
it's infuriating. It
if y'all have not seen this, where the tactical force goes in and this guy's back there shooting kids, right? And they're standing out there. And I say standing out there, say like you walk into the front of a school, like that's where they're standing. And 30 something minutes into this thing, if I have this correct, like 30 minutes into it, all of a sudden somebody says, "Did anybody check that room?" They're standing
yeah,
outside of a classroom and nobody had cleared the classroom, y'all. And I'm sitting here going, holy cow, you got like 15 cops or something like that out there. And you don't even know there's somebody in that room right
no,
there.
what about the officer who got texted by his wife? He was standing in the hallway like, "Let me go in. Let me go in. My wife's in there." And she's texting him, I'm shot. I'm hurt. Come save me." And they took away his force multiplier and dragged him out of there. There
Didn't like who ended up taking the guy out? Is it true that it was a um, um,
It was BORTAC, I believe. So
border control?
security,
Yeah.
border control security. But um, it seems like, and so here's the even more piss off thing. That BORTAC unit had to come all the way from Del Rio. They were an hour away. By the time they got
That's how long
there,
this went.
they were like, they were ramming police cars so they could get in because all those jackasses were hanging out in the hallway.
Y'all, Mo's got so much more on this case. Like seriously, like this is the most crazy thing. Like if you go back and like I said, like the Discord stuff, like there were rumors. If you remember, it was there was a black supermarket shooting in New York like a
Yes.
month or so before this, and they blamed that on Discord. So supposedly there's this whole conspiracy that people were planning these things on Discord, and Then, of course, we all know that last September 11th or September 12th was it? Charlie Kirk,
Yes.
and that was planned on Discord.
There was some allegations during that time that now the conspiracy I heard was that there was MK Ultra, or if you want to say CIA Fed help for a lot of these people, because there were questions about how this particular suspect in this shooting, who didn't have a job, didn't have any access to these firearms, how he got
I'm glad you said that.
very expensive rifles.
He had a Daniel Defense rifle. So the guy was on welfare, right? His family was on welfare. And he has a pickup truck. I mean, okay, so it doesn't have to cost a lot. But he had a Daniel Defense rifle. He had like, I think I counted up, you add up what I saw at the beginning. It was the number, for some reason I'm thinking close to $5,000 worth of stuff, because he had so many, he had so much ammo. And that's another thing, the ammo prices at the time.
Magazines. He had 6 magazines full, so they approximated either 160 to 180, I believe.
Yeah, 130
bullets.
rounds each. Yeah.
Yeah.
So, but he had more than that though, like at his house, and didn't he have some handguns too that he had all gotten within a month? The Daniel Defense rifle was at the time, it was like $2,000.
Yeah, that was right during the time where no one could find ammo.
Yeah, it was short. There was a shortage going on. Ammo was at least 50 cents. Got about 50 cents now. It was close to $1 a pop. So if you have 500 rounds of ammo, that's $500.
Yeah, so I do remember around the time that it broke, everyone was asking, how was he affording this? What did he get?
Yeah, he made more on welfare. He had more disposable income on welfare than I do.
Would you like to start a child-free daycare with me?
Yes. I need to get a tanning bed. By the way, that
no,
reminds me.
expert, when anyone asks us if we're Somali and we say, how dare you, couldn't you tell? No, we just brazen our way through. That's what we do, expert. We like, how dare you assume we're not Somali? Are you racist?
What do you mean? What do you mean? Define Somali. I am Somali.
So
I'm Somali now.
So it looks like we will be going back to regular trial tomorrow. They will be doing possibly whatever this cobbled together remedy is.
I'm sorry. I'm sorry, y'all.
No, I chose this. This one deeply affected me, and I feel like in a very small way, I'm sitting with the parents because I can't imagine the pain that they're dealing with.
Oh, yeah. Well, it's been
But
dragged
it's
out
not
for
an
so
easy
long.
trial.
No, it's not. And there's, I don't know. It's just, it's frustrating.
I just don't see the state being able to make a case that this man was uniquely responsible for the clusterfuck that was.
I wonder,
Yeah.
I want to know how the guy that did it, like his story was never.
Yeah, I want to know
walked
what
away
the hell
from it.
happened. I want to know what the hell happened in Las Vegas. Could we know?
I watched a new video the other night on that.
Ooh, send me the link.
I'll have to.
Is
Now
it
I'm gonna have to
Bigfoot?
find it. I should have thought about that before I said it.
Before you leave,
Yeah.
and before I end the stream, I have something that will make your day. Now, I
Yes.
can't play it because of copyright, but if you're feeling bad, if you're feeling blue, I have found the perfect thing for you. I really have. Sax Squatch.
That is really awesome.
Yeah. So he just plays music. Obviously, it's all copyrighted, so I won't be playing it. But now he does have Sax Squatch in space, which is him in a green screen. But this is possibly why I was born, to find this algorithm.
Well, this is why Al Gore did his work on the internet. Praise be him.
God bless Al Gore. Thank you for inventing the internet.
And the man bear pig. He protects us from man bear pig.
Yes. Well, thank you for joining, Expert.
Thanks
That
for.
is That's it for you for today, you guys. I have already been on stream like for a bajillion years, so I have to interact with my family now.
Yeah, go do family
Well,
stuff.
mostly be homework warden. If anyone would like to trade jobs with me for right now, because I'm going to have to explain to
You have
the.
more children than a Somali daycare.
I know. I totally miscalculated this thing. Had I known I would get benefits for not having children, I would have tried the other way.
I'm gonna have to. I'm gonna have to find some
Look,
links I saw
when
today.
when I, find something, I stick to my routine. Every 2 years a child for
Oh my
12
gosh.
I eventually learned how that happens.
Tequila.
Bye, you guys.
Did you see my mic fell? My mic fell down. It went limp. It did.